You're listening to the Today's Wills and Probate podcast, one of the leading sources of information for the wills and probate sector. Don't forget to subscribe and sign up to our free newsletter at todayswillsandprobate.co.uk and follow us on LinkedIn and Twitter.
Hello, welcome along to the latest Today's Wills and Probate podcast. Today we're talking about inheritance disputes, probate disputes, and to explore this topic with me, I have Hayley Gaffney, an associate at Coodes Solicitors. It's lovely to have you with us today on the podcast, Hayley. Thank you for joining.
Thank you for having me, David.
As I say, topic of conversation today is contentious, probate, contentious trust, Inheritance Act claims, and it's a topic on which you're an expert. So hopefully we can draw out of the conversation some of the challenges and some of the opportunities that might be out there for firms. In the first instance, though, perhaps you might tell us a little bit about yourself and your role at Coodes. And just before we started recording, you also told me you were a professional singer, so we have to explore that as well.
That was some time ago. I was a singer in a band. I was a bouncer, and then I became a lawyer, having started in a support role over a decade ago at Coodes and progressed through to associate. So I think that has given me a fairly unique perspective as well for the client journey. It's a sort of holistic view. And like you said, I'm an associate at Coodes, and I'm specialising in contentious trusts and probate, Inheritance Act claims, and contentious court protection work.
And the other interesting fact that you were telling me just as we were starting to record is that you have a long family history in Cornwall as well.
I do. I get asked by a lot of clients whether I am Cornish, because I don't specifically sound Cornish or what people perceive Cornish people to sound like. We act for lots of Cornish families and farmers, and I am 14th generation Cornish, I believe, from the last family count. But I don't sound it. It does tend to come out more when I am speaking to sort of family members and people with a broader Cornish accent. But I have, I think, an ability also, because of my background, to not just sympathise but empathise with clients and understand them. My family's very unconventional, and it's fractured itself. I grew up in a council house in a small village in Cornwall, and we weren't well off. We were probably by today's standards poor, and it certainly wasn't privileged or what others might perceive the usual background for a lawyer to be. And because of that, I think I understand complex family dynamics. And I feel that that's a strength that I have, especially for Inheritance Act clients, where they perhaps don't know where the next meal is coming from, or they have real significant money worries, or clients where receiving some funds from an estate or an award from the court really will change their lives. And I can see from that different perspective of not just a lawyer, but as a human.
One of the challenges I find with contentious probate in particular is this notion that we're a more litigious society than we ever have been. I mean, there's a massive influence, you might argue, from the likes of America. I find that really tough to kind of reconcile sometimes, particularly if you've got a case where somebody comes to you and it's not really clear that there's much of a claim here. Do you kind of deal with situations like that?
We will deal with situations. It's very difficult on first glance to know whether there is a claim and to be able to advise someone properly. We'll always be completely honest. And if there is just no prospect whatsoever, we act in the client's best interest and we'll always tell them that. But if there are particular nuances or points that perhaps need further investigation, we wouldn't advise them to just launch into litigation. And a lot of clients will do that, like you said, from the sort of American suing culture, which is rising. Rather than it being a last step, people see it perhaps as a first step, and it's drawing them back from that and getting them to perhaps take a step back. Whilst it's emotional, try to put some of that emotion aside and look at investigating it. We need to make sure that there's the merits, there's going to potentially be the evidence, and there is something to litigate. We don't want people sort of throwing good money after bad or arguing something that's just unarguable.
You're seeing in the family space the rise of mediation and the importance that's being placed on it as a alternative to going to court, and particularly with court backlogs, you can understand in part why that's happening. Is that a similar kind of thing that's happening here, that you're really trying to get people to look at more of a compromise before you start to go down the route of litigation?
Not necessarily before we go down the route of litigation, because you need to sort of build the foundation for a successful mediation. I'm a real believer in a mediation, especially where you have got a fractured family, where emotion is very overwhelming, and it's difficult for them to see past the points of principle and look at it from a more commercial, perhaps, perspective. And mediations are wrought with emotion, and you need to have the foundation for that. So whilst we absolutely advocate for mediations or alternative dispute resolution of some sort, even if it's just discussions with their solicitor, we do need, we do find that we need to do those initial investigations and set that groundwork to have the proper foundations for a successful mediation, because otherwise everybody's attending a mediation, which it still costs a lot of money. You've got your lawyers and the mediators, and so for that to be successful and have the best possible chance of success, there needs to be cooperation from both sides, and everybody needs to act reasonably. People see litigators as it's a confrontation, it's an aggression. You see the litigators get involved, or they're referred to the litigators, and they think, oh, here we go, it's going to be expensive, it's going to be contentious, it's going to be a big argument or lots of problems, and we're going to end up at court. But that isn't what we want. We want to act in everybody's best interests, and quite often that will be to go to mediation and try to resolve it, because there's more certainty. There's a much wider scope for the types of settlement that can be reached. You can really think outside the box, rather than the judge having perhaps more strict parameters as to what orders they can make. We can be much more flexible as well with a mediation, and that works a lot, especially where you've got farming families or wealth but perhaps tied up in various assets and things. So mediation absolutely works, but it has to be properly prepared.
I love the point you make about coming down from that point of principle, because people will often enter into scenarios like this with a chip on their shoulder. How do you deal with that? How do you get people to kind of just take that step back and say, hang on a second, look, what are the merits here?
It's very difficult. I was actually told when I was a junior working in a law firm when I was a teenager, that the most expensive sentence in the English language is "it's a matter of principle," because principles cost money, and principles don't necessarily correlate to having a claim, having merit, or it being beneficial to pursue something. And I'm very honest. Some say blunt. I'm not blunt per se, but I want to ensure that people are going into litigation or possible litigation with their eyes open. I want them to know the cost, how long this is going to take, the emotional strain they're going to be under. If there's fractures within the family that perhaps could be repaired, they're highly likely to be repaired once you've been to trial. I suppose my style, and lots of clients will say to me, we really appreciate the fact that you are honest, you understand what we want, you understand our objective. And I will say to them, I absolutely understand what you want the outcome to be, but you must understand that principles will cost money. You need to perhaps let go of that, put that aside. You can never stop people from having principles. You can never stop them from having that chip on their shoulder. And I completely sympathise with that, because with my own family background, I understand how difficult that is. Every contentious probate claim is different. There may be similarities with other cases, but everybody is unique. Every claim is unique. So it's really tailoring advice to the person and the situation, so that they understand that those principles perhaps are not something that they can pursue, or that they need to be set aside to a degree.
You can lead a horse to water, but you can't make it drink.
Precisely.
There has been an increase in the number of disputes in the last, I don't know, 10, 15 years. Obviously, it keeps you in a job. But what do you see that is contributing to that? I mean, we've talked about America. I think America has had some influence, but there must be some other sort of very specific influences that happen in England and Wales.
I think there are a number of things that are contributing to the increase in disputes. I think there's a rise in warring families, especially with the more complicated or blended families. There are people are more alive to things like dementia, which make them aware, and people will approach me and say, but she had dementia when she made the will. Dementia doesn't necessarily mean that they don't have capacity, but it could. But people are much more alive to things like that. I think homemade wills are quite more often than not shuddering. It's incredible the number of people who will perhaps save a few £100s by drawing up their own will or getting a homemade will kit. And it ends up costing their families and their loved ones tens of thousands of pounds further down the line once they're gone, because they've saved a few £100 now. Homemade wills are I think, a real issue, because people are also not aware of the criteria, things they need to include, the requirements for validly executing a will. People being more litigious, a more litigious society, which is probably compounded by the cost of living crisis. People are trying to find ways of perhaps getting a windfall or even extracting some sort of settlement from wherever they think there may be a possibility to do that.
I want to drill into homemade wills, actually, because again, I kind of sit here as an outsider looking in a little bit, because I'm not a lawyer, but I sometimes sit there and think to myself, there is a spirit in which this will has been written. You know, perhaps, as you say, there are some technical elements that are missing, but if ultimately this person has decided that that's how they want to split their assets, then surely their wishes should be respected.
Unfortunately, that's not how the law works. The best chance for someone to have their wishes to be fulfilled is to have a valid will. And to have a valid will, it needs to meet certain criteria. There are requirements that must be met. And even if someone does fulfill those requirements, and they perhaps look online and think, well, I know what I need to do, this is how I need to do it. And what we'll find sometimes with a homemade will, for instance, is someone will put the information in, their wishes are in there, but it's been done in such a way that actually the will itself might be technically valid, but their wishes aren't fulfilled because they've not been worded properly. So you'll end up perhaps with gifts that don't work, they fail, and so you end up with perhaps a partial intestacy, so other beneficiaries receive things that people wanted someone specific, a friend or a loved one, to receive. And in doing that, perhaps it then creates litigation where it wouldn't have been necessary. Whereas if someone goes to a properly qualified professional will drafts person and gets it drawn up properly, all of those things can be covered off as best as possible. That's not to say that by having a valid will, it necessarily means that your estate is administered that way, because people can bring claims. But it means that you've got the best possible chance and you've laid the best possible foundation for your estate being administered in the way you want.
There is an elephant in the room here that we haven't addressed, which is pandemic wills. Obviously, the pandemic saw a massive spike in the number of wills that were written, and there was some concern from the community that we would see some contentious matters arise out of that. Are we starting to see that happen now?
Oh, we absolutely are. As you said, David, it was a very worrying time for everybody. There was a lot of uncertainty, and especially the elderly and the perhaps more vulnerable were panicking. And those wills are now coming to light because people either now haven't updated those homemade wills that they did in a panic and perhaps didn't have witnessed because they weren't allowed to see people, or the ones that they were done in haste with solicitors, perhaps remotely, and they haven't now reviewed and thought, actually, now I'm perhaps more settled, have my intentions changed? There was legislation brought in, again in haste, that allowed for wills to be witnessed by video link, but there were rules around that, and they were slightly unclear at first, as many sort of rushed rules and laws were around that time. Will drafts people were busier than ever. There was a sharp rise in people suddenly realising their morbidity and wanting to make those wills quickly. And if they couldn't get an immediate appointment, or they were worried about contacting solicitors because it meant admitting that concern, and a lot of people, it is like you say, an elephant in the room. People don't want to talk about or think about death, and COVID very much made people have to do that, and it was brought to the forefront of a lot of people's minds. They were drafting their own wills. They were getting their friends to type them up on the computer for them, and it was much more difficult, even for professionals, to do the due diligence that perhaps they would have done before, pre-COVID, or which they do now. They were meeting elderly or vulnerable people by Teams or by video, and it's very difficult to assess someone's vulnerability, perhaps to undue influence. People were isolated. They were spending much more time and forced to spend much more time with individual people, and that led to the ability for people to just have somebody's ear. They had a captive audience, if you like, so they were able to cause rifts or compound existing rifts. Well, they didn't bother with you. Look at me, I'm here looking after you. And it's very difficult for the professionals who were drafting the wills to know what was going on in the background, because it's very different looking at a screen. You don't know what's going on behind that screen, rather than having someone sitting in front of you. And so even some professional wills, there are still issues that are coming to light, because it was just much more difficult for everybody, and everybody was thrust into a situation that was just totally unexpected and nobody was prepared for.
Well, here's a great opportunity to talk to somebody that's at the coalface of contentious matters. What kinds of things are you looking for? I mean, perhaps this is giving away trade secrets, I don't know, but what kind of things are you looking for in the will or and in documentation? And what can non-contentious listeners to this learn?
More often than not, there will be scrutiny of the will file. Somebody within one of the parties within that dispute will obtain the will file, and it will be scrutinised. And ultimately, the lawyer who has prepared the file and prepared the will could end up on the witness stand. They could end up in the witness box being questioned about the contents of that file. And I'm not meaning to frighten them, but it's a reality. We have had a number of cases recently where the solicitor who drafted the will has ended up in the witness box at trial, and it's uncomfortable, it's exposing, but if they've done the best they can to properly compile that file, they're most of the way there. So the possibility of being called to give evidence is lessened. So it's for their benefit as well as their clients. Specifically, we would look for thorough and clear and complete attendance notes, telephone notes, a letter to the testator explaining the clauses of the will. Wills, by their very nature, contain a lot of legal jargon. It makes sense to us because we see it every day, but somebody reading it is not necessarily going to understand what these step provisions are or what these other wordy clauses mean. So it needs to be explained in plain English. If there's any concern about potential claims, if they're leaving somebody out or they're deviating from a previous will, we want to see advice on those potential claims. We want to see consideration of their capacity. If somebody is going to be leaving somebody out of their will or drastically altering from their previous wills, we want to see perhaps a letter of wishes or a statement explaining their reasoning, because that's really useful potentially later in a claim to show their thinking and why they said it. Obviously, by the time I get involved, most of the time, the testator isn't around to give their voice, for their voice to be heard. So them having prepared a letter or a statement means that their voice can be heard, and that can be really important. contemporaneous notes, and I say this often, we want to see the note when it's fresh in the lawyer's mind, not weeks later. We want to see them checked. We've seen hundreds of will files over the years, and where there are gaps, omissions, misspellings, inaccuracies, that just excites suspicion. And some litigators will pounce on that. It compounds an outstanding concern because, well, if they can misspell it or use the wrong name, were they listening? Have their instructions been recorded accurately or properly? And it does them a disservice because they're doing such an important job. It's just making sure that shows and shines through with the file. You know, it's not always possible, but showing the thought process and the work that they've put into preparing that will and taking those instructions can be really helpful. And if that is evident from the file, they're much less likely to end up having to explain what happened because the file will show that for itself.
I think there's some really useful pointers in there, and I really appreciate you sharing that insight, Hayley. And I know that, for example, one of the things that you advocate for within Coodes is that if there's ever a query or ever something that comes up on the non-contentious side, that you've got a very open door for people to say, look, if this happens, you know, what would potentially be the fallout of that, or what might happen in this scenario?
Absolutely. We really do care. And I think that litigators are seen as perhaps the bad guy. They're the ultimate backstop. And a lot of people think that perhaps litigators only get involved when it does become contentious, but that's not necessarily the case. As you said, at Coodes, we've got a very much open door. We spend a lot of time speaking to our non-contentious colleagues about things that perhaps are slightly ambiguous or slightly obscure, perhaps. You may have people wanting to leave gifts or specific gifts to various people, and it things that even now we will still get things that we go, crikey, not seen that before. But also there are lots of things that you might think as a non-contentious practitioner, oh my gosh, that how on earth? And we've seen it before. It's nothing shocks us. You know, we've seen it before, and we are happy to help to find a resolution now and draft perhaps a will or something to go with the will that can preempt litigation in future. So we're really very happy to do that, and we would much rather help now than have to deal with it in the future and there be perhaps something that could have been done earlier on.
It's always much easier to do something when you start a process rather than when you finish the process, isn't it?
And much cheaper.
Yes. It's been fab to have you on the podcast, Hayley. We are out of time, and I hope that listeners have kind of taken away just some pointers, perhaps one or two things that they sort of think to themselves, actually, yeah, you know, when I'm drafting or when I'm thinking about this particular scenario, I do have a friend that I could lean on, or I've got a colleague that I can talk to. So it's been great to have you on, and thank you so much for sharing your insight.
Thank you very much for having me, David. Thank you.
Today's Wills and Probate podcast is available on your preferred podcast provider. It's also available on today's willsandprobate.co.uk. My thanks to Hayley. Thank you as ever for listening, and we'll see you again soon.
You're listening to the Today's Wills and Probate podcast, one of the leading sources of information for the wills and probate sector. Don't forget to subscribe and sign up to our free newsletter at todayswillsandprobate.co.uk and follow us on LinkedIn and Twitter.